My name is Todd Coulston. I'm a certified family law specialist practicing exclusively in family law. I'm a partner with the law offices of Burch and Coulston, LLP, in Irvine, California. And we represent our clients exclusively in all family law matters, which involve marital dissolution proceedings, parentage proceedings, drafting of premarital and postmarital agreements, and everything related to family law matters. In this situation, really a do-it-yourself divorce for this couple that has been married for a medium length of time, has several children, 2 businesses, and several properties, really is a difficult, unless it's completely amicable and just there's no value to any of the assets, they agree on their children and how to share them, really is a situation that isn't conducive for a do-it-yourself type of online divorce. Basically, you have several items here. You have 2 businesses which the spouses are operating. These businesses, in addition to providing the certain amount of income or cash flow for the spouses, also represent tangible assets that require valuation in a divorce proceeding for division. So in that situation, to value a business asset, which is sometimes quite complicating depending upon the size of the business. You oftentimes need to conduct discovery, obtain multiple years of financial records, do subpoenas to the financial institutions, and review QuickBook records, accounting software, tax returns to determine the valuation of a business. And in working with business owners in divorce, we frequently and commonly retain the services of outside forensic accountants to do the business valuation. There are certain methods and approaches to business valuation that only forensic accountants can provide expert testimony in divorce cases, and which require, in this situation, certainly, depending on the size of the business and the size of the dental practice, we would want to have that asset valued to determine if there is any tangible value to divide that asset in the divorce proceeding. Additionally, business owners have a different nature of compensation. In addition to possibly paying themselves a salary, there are many perquisites, benefits that may be legitimately deducted on for income tax purposes as an expense for tax purposes, which may be considered personal income for purposes of determining child support and spousal support. Therefore, again, to determine a true income available for support analysis in a divorce proceeding, you would need to hire and retain the services of a forensic accountant to review the financial records, review the payment histories, review the expenses, and determine the true total income that a business owner spouse has been earning for determining the calculation of child support and spousal support. These issues particularly commonly can't be done simply by the layperson, even the business owner themselves, while they may have intimate knowledge of their business and what they think their income is. There's a variety of definitions that, for purposes of support that they may not believe to be income, which actually is considered by the court in determining child and spousal support. So those two property issues bring a certain level of complexity that would require not only the services of outside accounting, but the advice of legal counsel knowledgeable with the how courts handle business valuation and income available for support. Additionally, whenever there's children involved, if there's any type of dispute on what's in the best interest of the children, what custody and visitation schedule, it's very difficult to have that done without the advice of counsel and potentially the intervention of the assistance of the court or outside professionals. So, again, depending on the situation, it's most likely in this scenario that the divorcing couple would be well advised to seek legal representation and legal counsel to assess their case at the outset prior to moving forward with an online or unrepresented divorce. In my practice, as a mediator, I have couples that jointly retain my services to serve as a neutral third-party mediator to assist them with negotiating a divorce settlement. Mediation is a confidential process where the couple meets with me in my office And basically, we engage in a series of ongoing discussions or negotiations guided towards trying to achieve an amicable, out-of-court settlement of their divorce case. Mediation best works with couples that are both invested in the process, that really want to participate, want to resolve this out of court, and want to have a settlement that they have control over, that the orders that they agree to are orders that they will agree to follow into the future. And when, in my cases where I've served as a mediator, the best results are where both parties, both spouses are active, embrace the process, and really actively participate, knowing that this will lead to an amicable resolution. So when the couple, the best mediation results are always when the couple embrace the process fully, are fully participating, and are recognize that an amicable resolution is far better than trying to fight it out in court, where a judge that has very little knowledge of them, relatively speaking, and of their family and of their case, is left to make a decision. So in the mediation process, when I meet with the couples up front, really try to emphasize to them that if they take control of the negotiations, they're the ones that come to the deal, and the settlements are more likely to be followed. They're likely to have a much happier result, a much better relationship post-divorce. Regardless, although the marriage is breaking down, from what I've seen, the settlements that are achieved through a mediated resolution lead to long-term satisfaction post-divorce, not only with the orders themselves, but with the interpersonal relationship that they maintain after the divorce has been completed. Additionally, you see a drastic reduction in the total amount of fees and costs that they have to incur for the entire divorce process, rather than each paying a significant retainer to separate attorneys, paying one individual, a retainer and fees and costs for their time. Leads, frequently, from what I've seen, folks that are motivated, active in the process, it leads to a much less costly process for them in the end. As a family law divorce attorney, we work frequently with mental health professionals, both with professionals that provide therapy to our clients, as well as professionals who provide therapy services to the children that our clients have going through the divorce process. We realize in our profession that divorce is an extremely stressful, life-changing process. We find commonly that just having, for both our clients and their children, having someone available to them that can be in a confidential setting, can be a sounding board that can provide counsel, advice on how to interact with their divorcing spouse, with their children, how to prepare their children for the process, how to prepare themselves emotionally for the process, can be quite beneficial as they go through this process. We are not afraid to recommend, even if we feel like, even if our clients feel like, okay, I think I have a hold on this, I think that I'm going to be okay through this, we still see the benefits of them at least talking to preliminarily a therapist or a counselor to keep them apprised of the situation, provide some initial psychological counsel so that they understand the process, understand the stages that people go through psychologically as the process continues, and so that they have a full understanding of what they're going through as they go through the process. So we found that mental health professionals have been very helpful with children, especially the children. Divorce can be an extremely traumatic process, no matter the age, whether they're very young or middle-aged children or teenagers. It can be traumatic even in the most amicable of divorces, where the children will even realize, mom and dad really need to be separate and apart. Having a counselor, having someone there that they trust, that they can rely upon in what is can be a period of upheaval for the children, it has found to be very helpful in helping the children go through the process, helping them to understand what they're going through, helping them to express to their parents what they feel, and also helping to the children to feel like they have a voice in the process. Oftentimes, as the children especially get older, the courts are permitted to consider their preferences in custodial arrangements more frequently as they become older in age, especially after the age of 14. In California, the courts are required to, or mandated to, consider their child's preference if they so choose. So a lot of times, mental health professionals, counselors are retained to meet with the children, determine their preference, and make recommendations to the court. They can be retained as court experts to make recommendations to the court, about their preference of their custodial arrangements, and provide an outlet for the children to express their preference in a non-threatening, confidential setting to where they feel like they have a voice in the process. So in both situations, whether it's our clients or for their children, the mental health professionals are very helpful, and we work very closely with them during the process.